Okay, the Michael Flynn judicial saga has officially been going on for so long, I have run out of intro jokes. Viva Frei, Montreal litigator turned YouTuber, and there has been another development in the Michael Flynn judicial saga coming by way of an order from Judge Sullivan on Friday afternoon. What we call in the industry the Friday afternoon special, Judge Sullivan calling on the Department of Justice to verify certain documents that the judge refers to as altered documents multiple times in the court order. Now, before I go over the court order, the arguments as to why it's potentially relevant, why it's potentially not relevant, just a bit of the context without going over the entire context of the Michael Flynn judicial saga. Alright, setting aside the entire context of the Michael Flynn judicial history, recently you will recall that there was a petition for rehearing en banc from a decision of the Court of Appeal granting Michael Flynn's petition for the issuance of a writ of mandamus enjoining Judge Sullivan to dismiss the case. And if none of that makes any sense to you, I invite you to watch my Michael Flynn judicial saga playlist, which I will link right here. I have been documenting the evolution of this case for, I think it's over a year now. Alright, as you can probably tell by the shift in lighting, I just fact-checked myself. I have not been covering it for over a year. It's been over a half a year, but it feels like it's been over a year. The Department of Justice filed a motion to dismiss the criminal complaint against Michael Flynn. Judge Emmett Sullivan, who's supposed to grant these things sort of as a rubber stampy-like matter of fact, does not grant the motion to dismiss, instead appoints an amicus to present arguments in opposition to the motion to dismiss. Sullivan's attorneys prepare a petition for the issuance of a writ of mandamus enjoining Sullivan to dismiss the charges. A panel of 3 judges of the Court of Appeal grant the petition for the issuance of a writ of mandamus 2-1. Judge Emmett Sullivan himself files a petition for rehearing en banc before the entire panel of the Court of Appeal. The entire panel of the Court of Appeal decides to rehear the matter not as a result of Judge Emmett Sullivan's petition for rehearing en banc, but sua sponte, of their own motion. They vacate the original decision of the 3 judges of the Court of Appeal, return the entire file to Judge Emmett Sullivan to adjudicate on the Department of Justice's motion to dismiss in a timely manner. The hearing on the Department of Justice's motion to dismiss that was referred back to Sullivan was heard on September 29th. It lasted over 5 hours, and during that time some amazing things occurred, which I highlighted in a vlog summarizing that hearing. I'll link it right here. I don't think I'm exaggerating when I say that one of the most surprising things to have occurred during the September 29th hearing before Judge Emmett Sullivan was his reliance on a letter he had received from Peter Strzok's attorney on the eve of the hearing that was not filed in the court record and that was not communicated to the other parties in the file. Relatively unheard of for a judge to rely on ex parte communications, that is to say communications that were not communicated to the actual parties in the lawsuit by persons who are not parties in the lawsuit, of documents that are not evidence in the lawsuit. The letter from Peter Strzok's attorney, and for those of you who don't know who Peter Strzok is, he is one of the disgraced former FBI members who was fired as a result of rampant political bias. Setting aside whether or not you think employees are entitled to have their own political bias, I think we can agree to disagree on that matter, especially when those employees are conducting investigations for the FBI. Regardless, put that debate on the back burner. The letter on which Judge Sullivan was relying was a letter from Peter Strzok's attorney claiming that his FBI notes of certain events taken at the time were in fact altered. Judge Emmett Sullivan, in relying on this ex parte communication received on the eve of the hearing that was not communicated to the other parties, was not submitted as evidence following the standard adversarial process, said that he was floored by the contents of this letter. Now, it seems by all accounts that the manner in which this document was altered is that it was photocopied with a sticky note on it, placing a rough timeline of the notes that were the document itself. Why is it relevant? What could it possibly change? We're going to get into that in the context of this vlog, but first, let's just walk through the court order. It is long, it is tedious, it is wordy, but I think we need to read through it in its entirety so I don't get accused of taking anything out of context. Minute order as to Michael T. Flynn. During the September 29, 2020 motion hearing, the court informed the government that it would need government counsel to authenticate documents filed with the court. On October 7, 2020, the government filed 259 Notice of Compliance in which it stated that 1. Federal Bureau of Investigation FBI agents assigned to review Mr. Strzok's notes had placed sticky notes on the document with estimated dates, and the sticky notes had not been removed prior to scanning the documents for production purposes. And 2. A sticky note with an estimated date had been placed on the notes of Andrew McCabe, and the sticky note had not been removed prior to scanning the document for production purposes. The government stated that the notes of Mr. Strzok and Mr. McCabe were otherwise unaltered, and it provided the unaltered versions of Mr. Strzok's and Mr. McCabe's notes. However, the government did not address pressed the court's authentication request despite the government's acknowledgement that the altered FBI documents have been produced to Mr. Flynn and filed on the record in this case. The government has filed a motion to dismiss pursuant to Federal Rule of Criminal Procedure 48A, has attached 13 exhibits to that motion, and has cited the exhibits throughout its motion to support its description of the factual background and its argument in support of dismissal. The government has also filed a supplement to its motion and attached an exhibit to that supplement. Although the government relies heavily on these 14 exhibits, the government has not provided a declaration attesting that the exhibits are true and correct copies. Quote, the presumption of regularity applies to government-produced documents, end quote, and, quote, to the extent it is not rebutted, requires a court to treat the government's records as accurate, end quote. Here, however, the government has acknowledged that altered FBI records have been produced by the government and filed on the record in this case. Accordingly, the government is hereby ordered to file by no later than October 26, 2020, a declaration pursuant to penalty of perjury under 28 U.S.C. Section 1746 in support of its motion to dismiss that the exhibits attached to its motion and supplement are true and correct copies. It is further ordered that the government's declaration shall identify each exhibit by name, date, and author. It is further ordered that the government shall provide transcriptions of all handwritten notes contained in the exhibits. The government has also filed on the record in this case numerous notices of filing discovery correspondence, and Mr. Flynn has generally filed the discovery produced on the record in this case as exhibits to his supplemental filings. The government has acknowledged that the discovery provided to Mr. Flynn and thereafter filed on the record contained altered FBI records. Accordingly, the government is hereby ordered to file by no later than October 26, 2020, a declaration pursuant to penalty of perjury under 28 U.S.C. Section 1746 that the discovery documents provided to Mr. Flynn and filed on the record in this case are true and correct copies. It is further ordered that the government's declaration shall identify each discovery document by name, date, and author. It is further ordered that the government shall provide transcriptions of all handwritten notes contained in the exhibits. Signed by Judge Emmett G. Sullivan on 10/23/2020. Text entry, no document attached. All right, now we have an understanding as to what these altered documents are. They were in fact photocopies of FBI notes that had been photocopied with a sticky indicating a rough time frame that those notes were taken in. Whether or not that qualifies as an altered document to you is a matter of opinion. What I find relatively striking is the fact that Judge Emmett Sullivan uses the term altered 3 times in his court order to refer to those documents. Hey Siri, what does altered mean?
Changed in character or composition, typically in a comparatively small but significant way.
Some people might be of the opinion that accidentally photocopying a document with a sticky note on it does not necessarily qualify as altering the document. We may agree to disagree on that point, but why is it relevant? An article in Politico attempts to explain why it might be relevant. Judge orders Justice Department to verify its filings in Flynn case. The order is a signal of intense distrust between the judge, Emmett Sullivan, and the department, whose filings are typically accepted at face value. In this case, DOJ has already acknowledged that 2 documents it previously filed, handwritten notes taken by former FBI counterintelligence agent Peter Strzok and former FBI Deputy Director Andrew McCabe, were altered, quote, inadvertently, end quote, to include inaccurate dates. And here is the crux of the purported relevance. The alteration in Strzok's notes have already led to a significant public confusion about a key aspect of the FBI's investigation of Flynn. Strzok's notes summarize a January 5, 2017 Oval Office meeting at which President Barack Obama, FBI Director James Comey, and other national security officials discussed Flynn's contact with Russian officials. The document filed in court included a notation that indicated a date range of January 4 to January 5, 2017, an addition that DOJ attributes to an inadvertently scanned sticky note. Despite little ambiguity about the date of the Oval Office meeting, the inclusion of January 4, 2017 as a potential earlier date helped Trump deploy the issue during a debate last month with former Vice President Joe Biden. Strzok's notes indicate that Biden mentioned the Logan Act, a mostly defunct 18th century law that criminalizes efforts by private citizens to conduct U.S. foreign policy. The FBI internally discussed using the Logan Act as a basis for its decision to interview Flynn a few weeks later as it investigated his contacts with Russia's ambassador to the United States. Ultimately, FBI and DOJ officials said the interview was conducted as part of the FBI's counterintelligence investigation of contacts between the Trump campaign and Russia. Strzok's notes provide no context about why Biden raised the Logan Act, if it was in response to anyone else, or how any officials responded. Biden has previously acknowledged being present in the Oval Office during the discussion of the Flynn matter and indicated he was broadly broadly aware of the FBI investigation. Quote, "But that's all I know about it. I don't know anything else," Biden said. Trump, though, accused Biden of dredging up the Logan Act himself to go after Flynn. Peter Strzok's otherwise undated notes refer to a meeting during which VP Biden referred to the Logan Act. Strzok's notes being undated for whatever the reason, apparently the Department of Justice put a little sticky note on those notes to indicate a rough time frame when that might have occurred. And apparently they indicated the time frame of January 4th to January 5th, 2017. The argument is that it is widely known when that meeting occurred and that it was on January 5th and not January 4th, and that by predating the potential date of that meeting, they somehow implanted the idea that it was Joe Biden himself who first raised the Logan Act. And seizing on this confusion and calling it an altered document, Judge Emmett Sullivan is now demanding that the Department of Justice verify and confirm its filings under penalty of perjury by tomorrow, as of the time of shooting this vlog, October 26th. That is my understanding of the issues at play here, why it's relevant, why it's not relevant, and some might just come to the conclusion that none of this is relevant. Whether Joe Biden was the first person or the second person to raise the idea of the Logan Act, I think the relevant part is that Joe Biden raised the Logan Act in a meeting with Barack Obama as to how to deal with Flynn. Does anyone care if it wasn't his idea originally? I don't know. I guess that might depend on what side of the political aisle you sit, but some people might not care whatsoever. Some people might be asking themselves, why were Peter Strzok's and Andy McCabe's notes not dated in the first place? How's it going? After all, these are FBI agents at the highest levels of the intelligence agencies. They know how to take notes, and they know that notes should be dated properly. Others might understandably be thinking that Judge Emmett Sullivan is exploiting of the opportunity to create yet additional delays in this file, although in reality, he didn't really add much of a delay. He issued this order on Friday, and the order comes to fruition on Monday. But others might also be thinking that Judge Emmett Sullivan actually has a doubt in his mind of the authenticity of the underlying document itself. The reality of Judge Emmett Sullivan's orders is that he doesn't just want an explanation as to the sticky note, he wants confirmation that the underlying document itself hasn't been altered, as if to suggest that the Department of Justice would have actually altered documents it submitted to the court. Again, this may be more or less plausible depending on which side of the political aisle you sit on, but it does suggest that Judge Emmett Sullivan actually thinks the underlying documents themselves might be fake. We will see what happens tomorrow as of the time of shooting this vlog, but I strongly suspect the DOJ is just going to confirm the authenticity of the underlying documents, and we are going to move on. As far as I am concerned, a cynical lawyer turned YouTuber, reading Judge Emmett Sullivan's order, I got the impression he just wanted to use the term altered document as much as possible so the media could run with that term. Refer to the document as altered 3 times in the court order to create the general impression in the general public that potentially the Department of Justice's evidence at large has been altered. Or maybe I'm just getting too cynical in my old age. That being said, there will necessarily be follow-ups because there will necessarily be developments. I will be talking about this and other issues in my live stream with Robert Barnes tonight. If you're not familiar with that, we do live streams every Sunday and they are awesome. Link right here. If you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comments. We've got PayPal, Patreon, Subscribestar, YouTube membership. All members and supporters get sneak peeks of the vlogs in as much as I can provide them. There's also merch for anybody who wants to get merch. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.